Good morning, Your Honor. Thank you very much. I'm Marshall Reisman. I represent Dr. Baltasar Jimenez, appellant in this matter. I want to say, first of all, I want to correct an error. I agree that the standard of review is abuse of discretion, not whether the ruling was erroneous or whether the court erred. I agree with abuse of discretion, but that does not change our argument.
Do you want 5 minutes to rebuttal?
Yes, I apologize. Yes, I do. Thank you. As noted in the appellee's brief, the standard for abuse of discretion is whether the ruling is not supported by substantial competent evidence, whether there are clearly erroneous legal conclusions, and whether the court ignored the plain meaning of the MSA, the settlement, and the record. Now, I'm not particularly comfortable suggesting that a circuit judge and magistrate acted arbitrarily or unreasonably. In fact, I've never been quite in this position before. But by the same token, I think it's inescapable here. It is inescapable here because what happened, and I hope this was laid out sufficiently in the brief in terms of the background and context of this case. This was a long-standing divorce. The final judgment and marital settlement agreement was entered into in 2014. Between 2015 and 2018, there was, how shall we say, hot disputes between the parties. Dr. Jimenez was found in contempt more than once. And in 2018, he filed a bankruptcy, initially a Chapter 13 bankruptcy, not with me, and then I substituted as when he converted to a Chapter 11 bankruptcy, which was significant in this context because Ms. Jimenez, Melba Jimenez, filed a proof of claim in that Chapter 11 bankruptcy. The bankruptcy court lifted the stay for the folks to liquidate their claims before the circuit court. They came to a settlement, a comprehensive settlement in 2020, whereby both parties released each other from anything that had gone before. And it was not a novation, there was a modification, and the specific modification that was announced and incorporated by reference by the circuit judge.
The foreclosure sale and the creation of the surplus occurred after the effective date of that?
Yes, but it was contemplated in the stipulation for settlement. And part of that stipulation for settlement was that the parties were to abide by the consent final judgment of foreclosure that had been entered into.
Well, isn't that the rub?
I'm sorry?
That's the rub of the problem. As I understand the MSA, it contemplated an amicable sale of the marital property.
Yeah.
I understand Mrs. Jimenez is a realtor, so it would seem to go smoothly. And as I understand it, Dr. Jimenez didn't do the sorts of things he was supposed to do to facilitate the sale of the marital home, and as a result, that portion of MSA sort of failed, and it ended up in foreclosure and a foreclosure sale.
Well, I would suggest that it didn't fail in that sense because there was a prior ruling, and it was noted in the briefs that Ms. Jimenez, who was a realtor, was to market the property and bring the property and try to sell the property, and the only offer that she brought forward was $400,000 less than.
Might that have been because she was unable to show the property on, what was it, 14 attempts to show that he blocked the showing?
Well, that was, I believe that was found by the circuit court. By the same token, what was my response would be, what was the point of the release in 2020? All of this stuff happened before that. Dr. Jimenez was being penalized for, and I'm not going to dodge it, for bad behavior and perhaps contemptible behavior that he was found in contempt for, rightly or wrongly, between 2015 and 2018. 2020 comes along and they say, okay, we're going to clear the deck here. We're going to have this sale. We're going to modify the settlement agreement, and Dr. Jimenez is going to pay an additional $1,000 in child support.
Sebastian, for Sebastian's care.
Yes.
So I had a little trouble following the mountain ball on the modification, because the way that I understood it, it was basically recited into the transcript at the hearing where this was put to, I think, Judge Gould. Was there ever a document or some, I couldn't find this reading the record, where paragraph 6.2 was addressed in the context of that release in the 2020 modification?
It was only addressed in the sense, in the order approving the stipulation. Now, I was not the attorney for Dr. Jimenez in the state court at that time. I was over in the bankruptcy court trying to get all this resolved. Be that as it may, the only thing that addresses that, and I think is binding and significant, is that the order approving the stipulation, which was transcribed, read into the record, filed, and the order reserved jurisdiction to enforce the MSA as it was, except as modified, and to entertain any future modifications. So that would rather.
If that survived, don't we still have a problem with the fact that your client may have breached the terms of the MSA as it related to the sale of marital property?
That would be true, except that there was a release here. That's the whole point
So
of the
you're
release.
arguing that whatever breaches he committed, and he might have committed them by contemptible conduct, were released by this transcribed modification.
Exactly. Not only transcribed, approved, reservation jurisdiction, and approved by the bankruptcy court.
Did the parties sign another document evidencing the modification, or was it just the stipulation in the read-in?
It was just a stipulation read into the record, both parties amply represented by counsel, but approved not once, but twice. Once in the circuit court, and then it had to be approved in the bankruptcy court. And it was approved in the bankruptcy court without any objection. Ms. Jimenez had the same lawyer in both the circuit court and in the bankruptcy court, Ms. Roberts, and without objection. And Ms. Jimenez, as part of the deal, and this is very significant, withdrew her proof of claim in the bankruptcy court. So all this stuff that she was aggrieved about that occurred between 2015 and 2018 was part of a proof of claim that was filed in the bankruptcy court.
Is a practical matter, because I don't know much about bankruptcy, but didn't she have to release the proof of claim in order to facilitate the sale of the house?
I'm sorry?
If she hadn't released the proof of the claim in bankruptcy, if she hadn't released that claim, would it have been possible to conduct the foreclosure sale?
Absolutely, because the mortgage lender had the stay lifted to go forward with the foreclosure.
Like Judge Liebert, I'm having trouble following the law. So your client arguably does some bad things that make it difficult to sell a marital home.
Correct.
We'll take that as a given.
No, I'm not going to argue with that.
And because of that, the house goes into foreclosure.
Partly, yes.
He and his ex-wife sign a waiver.
Okay, they enter into a stipulation announced to the court.
Which you say waives any claim coming out of the nasty things he did.
Yes. And I think that the clear unambiguous language.
But now we have a foreclosure sale which generates a surplus. It's not the sale that was contemplated in the MSA. And now your client comes in and says, oh, by the way, I want credits for the mortgage payments I made, if any, and I want half of the proceeds.
Yes. Okay. Yes, the MSA does not specify what kind of sale. That's number one. Although I could see, I could see some discomfort and understand if I was on the other side.
Well, you wouldn't need a real estate broker, generally speaking, for a judicial sale. And the MSA specifically contemplates that Mrs. Jimenez would have been a facilitating broker on the sale. So, yeah, we could talk about what the MSA contemplated a foreclosure sale at all, but that's really neither here nor there. We should keep addressing Judge Libert's question.
It says sale. It doesn't distinguish between foreclosure sale or market sale, although there was a contemplation that Ms. Jimenez would be the realtor. However, what's particularly significant here is that the applicable statute And the original filing by Ms. Jimenez was for a 50-50 split of the surplus. Dr. Jimenez files a motion saying, wait a second, I'm entitled to principal pay down. And the response was, no, we not only oppose that, but we think because you were such a bad guy, you shouldn't get a dime. You're not going to get anything.
And if I may, Mr. Smith, you acknowledge at the beginning of the oral argument, this is an abuse of discretion standard.
Yes.
And as you know, with marital issues like that, courts of equity, trial courts sit court of equity to do equity. How do you respond to the fact that because it's a court of equity in making this decision, it just felt like granted in light of the bad behavior, and the process was this house was worth a lot more if your client would have cooperated way back when. And because of your client's behavior, it led to this position, which is a foreclosure, regrettably, with a drastically reduced value. And so what the court did is like, okay, let me do equity. There's evidence in the record that the former wife spent a lot trying to fix the problem, trying to correct. I guess at one point he added a room that was not coded, that you had to undo it. So the court looked at all of that and realized, we sit at a court of equity, let's do equity. Your client is not going to be entitled to any surplus because you'll look at all the money that the former wife has done, and given the abusive standard requirement, how can we say that the court was not wrong in coming to that conclusion?
The exercise of equity is not 1,000% without any boundaries. Here there was a release. Here, all of the stuff that was complained about by Dr. Jimenez's behavior took place before the release. In the absence of that release, I would agree. But that release was clear and specific and unequivocal and unambiguous. And the exercise of equity does not, in my view, and I think the case law upholds that, does not authorize the ignoring of a release and to throw it out, just throw it out in the circular file and say, okay, this release that y'all signed and everything that everybody did in consideration for this release that has been implemented and that benefits have been accepted by Ms. Jimenez, for a year or more before that. We can't just ignore that. And also, and I point this out, a fundamental principle is that.
Well, wait, what the magistrate and the trial judge adopted, the magistrate's findings, and this goes to what Judge Curzon was asking you about. Can you agree that, or at least conditionally agree, that the former husband's conduct could have been a breach of his obligations under 6.2, right?
Yes, but I would suggest that those were released.
And so what the magistrate said about that was, and she recognized the existence of the 2020 agreement, but she said he's not entitled to materially breach the provision 6.2 and then seek to enforce the remainder of the provisions to obtain a favorable result to benefit himself. And I think that's really the heart of what Judge Curzon was asking. I understand what you're saying. Courts of equity can't just do whatever they want because they think that's the right thing and have some boundaries. But in what way did the magistrate get that wrong? He's not entitled to breach and then seek to obtain a favorable benefit.
Because Ms. Jimenez released those breaches and accepted the benefits of
Did
the
she
agreement.
specifically release them, did she?
There's a blanket release.
Yeah, but what the release does is it prevents her from asserting any damage claims against the former husband. That's independent of the trial court trying to figure out how I'm going to divvy up surplus funds from a foreclosure sale.
I would respectfully disagree that the language of the release was from any and all claims from.
She can't sue him for damages for anything that happened beforehand. But what's happening here is I got a surplus and the trial court's trying to figure out what to do with it.
Well, this is a damage arising from, this is essentially saying, well, forget the settlement agreement, forget the MSA, you were a bad guy, Dr. Jimenez, so you don't get anything. But you entered into a release.
You've used 15 minutes, I just wanted to warn you so that.
Okay,
Use your time, Mr.
I'll reserve,
Okay.
but I believe, I would suggest that that was the essence of the mutual release.
Thank you, sir.
Thank you.
Your Honors.
Good morning.
Douglas Orr, here on behalf of the former spouse Melba Jimenez. Mr. William Wong wrote the brief I'm here to argue this morning in front of your Honors. Thank you for your time today. I'd like to begin by saying the issue here is whether it was an abuse of discretion for the circuit court judge to deny the appellant husband the proceeds of the property foreclosure. That's really the main issue. There's a couple other issues that have been briefed and that have been argued this morning, but I think that's the primary issue. And it seems to me, as we distill these issues, the primary consideration is what was released, if anything, by the language in the 2020. The 2020 release, which kind of reiterates what was in the 2014 marital settlement agreement, releases counts, claims, and causes of action. It doesn't extinguish facts. It doesn't extinguish issues. It doesn't extinguish the factual matrix that arose that brought these parties before the court and that led to the foreclosure proceedings. Those can still exist. Yes, perhaps she can't sue him for any of those bad things. Maybe she can't raise them as affirmative defenses, but those are facts that are rightly and properly under consideration by the trier of fact, in this case, the magistrate. And that's what happened. The marital settlement agreements and its terms don't extinguish those facts. It's almost, I'm not going to concede that it's moot, but it kind of doesn't matter whether the release language is binding here, because it doesn't refer to or address the issue of what Dr. Jimenez did or failed to do that led to the foreclosure, that led to the waste and the diminishment of assets, that led to the greater deficiency in the foreclosure proceedings and so forth. And that's really, I believe, what's at issue before the court this morning.
I'm a little troubled by, even if we take that Dr. Jimenez did not act probably in the best manner, if this Judge Guzan says we look at this as an equity situation, this was a marital property, so it was a marital asset, and it's now disposed of, and the doctor gets absolutely nothing. And I could understand easily, you're not going to get pay down credits, but he gets absolutely nothing. So allay my concern.
It's a good concern. This was a rich family. They had a bunch of assets. They had multiple properties. I can't remember how many, but they had more than one. This was just one property. There were other properties that the couple owned and that were ultimately sold. This is the one that was disputed in this fashion. He did receive other distributions from the sale of other assets, including other real property. I can't recall how many other real properties there were, but he wasn't cut out entirely. It was simply vis-a-vis this particular property that he took nothing.
Is one way of looking at it that, yes, it was a marital asset, but he wasted his piece of the equity in it when he did the bad acts?
Absolutely. In Appellee's brief, we really detail those specific findings and those bad acts that he committed, especially with regard to the property. He was supposed to, in 2014, I think the words are immediately and quickly, list and sell the property. And he didn't do that. Your Honor, there were 17 or 18 showings that he blocked, not 14, that led to, ultimately getting a pretty low offer and not leading to a sale that led to the foreclosure. One of the things he did, and this is in the record, he said that he wanted to try to convert it into an Airbnb. So he committed some, I think $216,000 was the estimate of improvements to the property that kind of failed and that had to be fixed. I think there was an estimate from, I think it was called Green Acres Homes, some sort of contractor to come in and fix what he tried to do. He was trying to turn it into an Airbnb during this 4 or 5 year period when he was supposed to be immediately and or quickly selling and listing the property. So this is all directed really at his behaviors and failures to act with regard to this particular property, the Minnesota Key, I think that's the name of the street, the Minnesota Key property. It's not for the rest of the property. So he wasn't denied any proceeds of the marital settlement, just this property.
Does the case rise and fall on whether we see the release that's in the 2020 agreement as being inclusive or exclusive or ambiguous as to this specific asset and this conduct relative to it? In other words, if the release is a general release of everything that had happened up to from the beginning of the world until the day the thing was signed, sealed, delivered, ratified, approved, whatever. But if that's the case, then is that the end of the day for your client, and is it that black and white?
I don't think so, because we still have equity times equity. This is a marital dissolution, which is an equitable process. It's up to the judicial discretion of the court, the trier of fact, and it's also the distribution of foreclosure proceedings. I believe the foreclosure court explicitly, and it's in the record, kicked it back to the circuit court to figure out what to do with these, the distribution of these assets. Foreclosure is also an equitable proceeding. So we have two different equitable proceedings that were before the trier of fact. In such a situation, the fact that the contract extinguished or didn't extinguish everything that happened before it doesn't really matter, because the court can still seek to do equity. In addition to the fact that the date of that agreement that was entered onto the record is June of 2020. The foreclosure proceedings happened afterwards. So the court it's still within the court's ability to look at the factual issues, if not the legal issues, that happened prior to the foreclosure sale, even if it's in that window of period of time.
Under your view, we could the foreclosure would almost sort of relate back in terms of his conduct to work around the release. Am I understanding you correctly?
It could. It certainly could. It doesn't have to work. Excuse me. It doesn't necessarily have to work around the release, but it certainly could. The foreclosure is outside the scope of the proceedings of the marital settlement agreement, and it even happened, after the agreement was entered into. So it's sort of axiomatic, and as a general black letter law proposition, you can't release future events. And this was a future event, even if it was sort of looming on the horizon and the parties knew that it may come. The foreclosure was filed in 2018. So when this agreement was entered into 2020, the foreclosure was a thing, but it still hadn't been resolved. And it didn't necessarily have to go into a foreclosure sale. The foreclosure sale didn't happen until October 29, 22. So more than 2 years after they entered into the 2020 agreement.
I think, Mr. Long, if you look at the actual, the amendment, and I just pulled it up, quote, the parties agreed to fully release and discharge the other from any and all actions. Claims for attorney's fees, costs and causes of action. So if you read it literally, it's for any claims, any action, not an existing foreclosure case that was or a matter. It's like for any future suit. If your client decides to sue her former husband for something, this release would say, sorry, you're barred by it. And so even look at the literal language of this marital settlement agreement, I have difficulty applying it to this particular foreclosure sale.
And that's because of the specific language that Your Honor just read?
It's very clear, any and all actions. If it really wanted to distinguish, it could have said, will distinguish any current or existing claims, but it doesn't have that. Any and all claim actions, claims for attorney's fees and causes of action.
And if, Your Honor, yes, and if that's the case, then that would also extinguish the husband's claim for half the distribution of the foreclosure proceeds. Obviously, the husband brought the action for the distribution. That's not what the husband thought this meant.
And it goes back to what Judge Barone mentioned, and even Judge Barone. If you look at that paragraph 6.2, it contemplates both sides. I mean, not only it's like, yes, you'll get credit, but also to comply. I mean, he can't have He can't have it both ways, to obstruct one portion of it and then claim another portion of it, which goes back to my initial question of Mr. Reisman, that the court sits in equity, and that's what the beauty about these type of cases. The court consider this in its totality. And so not just equity, but here we have the high burden of an abuse of discretion, which is really hard. Can you really say that no reasonable judge in the entire state of Florida would have come to the same conclusion? I'm having, and maybe this is more directed, Mr. Reisman, than rebuttal, but I'm having a hard time understanding that.
Once the contract has been breached, broken, busted, blown up, which is what the husband did with his repeated violations of its earlier terms, there is then nothing to enforce, including the release provision. He cannot then stand there. I breached all my duties under the contract, but I would still like to enforce the release provisions of this contract that I otherwise have destroyed in every way possible by failing to perform my duties under it.
Enforce the provision that lets me collect half of the surplus.
I'm sorry, Judge.
To say all of those things, and I would like to enforce the provision that entitles me to half the surplus.
Correct.
Credits for any payments that he may or may not have made.
Correct. There is a case, and I forget it right now, but it talks about chutzpah. It's kind of famous, and he's got the chutzpah to say, I've completely broken this contract in every way, but I want you to enforce the release provisions against my wife, but not against me. I do want the distribution. She can't get the equitable distribution of the foreclosure proceeds, but I would like it. That's what he's saying, and you can't have it both ways.
And we've read it in a lot of family law cases. There's a lot of chutzpah.
Of course. Of course. And I think that's all I have to present to the court.
Thank you, sir.
Mr. Reisman, I telegraphed my question to you because I'm having a hard time.
Well, and I understand it's, this was all easy, we wouldn't be here. And I get that. But I do want to point out certain things. Number one, when you say that he blew up the settlement agreement, well, the circuit judge, as part of this stipulation and settlement, the subsequent settlement of 2020, not the settlement of 2014, reserved jurisdiction to enforce the agreement of 2014. That remained intact. That remained intact. And our position is that any violations of that agreement prior to 2020 were released. And he was being penalized for violations that occurred before that. That was the contemplation. That was the intention of the parties, manifested by Ms. Jimenez's release and withdrawal of her proof of claim in the bankruptcy court. She didn't have to do that. She didn't have to agree to that. The foreclosure could have gone on and proceeds could have been held in escrow until the bankruptcy court decided who got them. And that happens all the time. Or the circuit court decided who got them. That happens all the time. But no, she released her proof of claim. But what did she get for the release of the proof of claim? What was her acceptance of benefits, which is an essential component of judicial estoppel or equitable estoppel or just a point in equity? She owed BB&T Bank $150,000 in her own stead, separate and apart from Dr. Jimenez. He agreed to satisfy that. He did satisfy that. It's part of the record because BB&T became truist and they withdrew their claim from the bankruptcy court when Dr. Jimenez paid $100,000. He went out of pocket $100,000 to honor this agreement. He also agreed to pay the extra $1,000 a month in perpetuity to honor this agreement. Ms. Jimenez, as part of her end of the deal, withdrew her claim in bankruptcy. She didn't have to do that. She could have said, you know, forget this. Have the foreclosure sale. We'll fight over the surplus, if any, later. She had filed a claim for over $400,000, which, you know, claims are funny things sometimes. But she could have said, forget about this. I want to litigate. I want to keep litigating. I'm going to fight this. And Dr. Jimenez has got a confirmed Chapter 11 plan. He's making his payments under that plan. She withdrew her right to participate in payments under that plan in consideration for the benefits that she received. So she can't take the benefits on the one hand and disavow the release on the other hand. That would be
You
inequitable.
can say the same thing about your client's position.
I'm sorry?
You could say the same thing about your client's position. He's taking the benefits of the release and claiming still the benefits of 6.2 unmodified.
I agree, but, and if there wasn't a general all-encompassing release as part and parcel of the deal is a deal. Sometimes deals are good, sometimes deals are bad, sometimes in retrospect, hindsight is 20/20, but the deal was a deal. They wanted conclusion here. The settlement, the MSA remained intact. They were going to complete the foreclosure. They didn't know if there was going to be a surplus or not. There was, Ms. Jimenez did not appear at the magistrate hearing at all. There was, the only reliance in the record was the prior orders, which were generated between 2015 and 2018. She didn't come to court. She didn't bring anybody to say what the property was worth, what it could have been worth, because, due to the market and other factors, there was a very, very substantial surplus. And she could have contested that. She didn't. She didn't show up. There was no substantial evidence other than the orders that were previously filed in the record prior to the settlement agreement and release. And so she didn't show up to even say, hey, this property should have been worth $2.5 million. She didn't show up to say that. No experts, no current value was presented at the hearing before the magistrate. She filed the motion to split the proceeds 50-50. When he said he wanted the principal paid down, he said, well, I'm going to get another lawyer and we're going to argue that you don't get anything. And that's the way that went down. Her original position was to split 50-50. And didn't say anything about disavowing the release, and later argued in the brief filed before the magistrate that the magistrate had the discretion to ignore the stipulation and the modification.
With that, sir, you have to wrap it up.
Thank you. And just one other thing, I did file a motion for appellate attorney's fees, and I like that noted and addressed if Your Honor deems appropriate. Thank you.
Thank you, sir. Thank you both. We're going to take a 10-minute recess and we will return for our last case.
All rise.